All right. Good morning to you. Are you Jacob Edwin Mullins?
Yes.
All right. Thank you. And Mr. Feigelson, if you would enter your appearance, please.
Yes, Your Honor. Good afternoon, Assistant Public Defender Stephen Feigelson, on behalf of Mr. Mullins, who's present by way of video conferencing this afternoon.
All right. Thank you. Mr. Mullins, this is a felony complaint indicating on or about January 24th of 2025 at 216 East Thomas Street, Lansing, Ingham County, Michigan. Sir, count one alleges that you did willfully and maliciously burn, damage, or destroy by fire or explosive personal property with a value of $1,000 or more, but less than $20,000. That is contrary to law. It is a felony, carries a maximum penalty of 5 years and or $10,000 or 3 times the value of the property damaged or destroyed, whichever is greater. Do you understand the charge and the maximum penalty, Mr. Mullins?
I understand your perspective of what occurred and outside
Well,
of that.
hang on. Before you go too far, this is just what's written on the paper. You
Yeah.
are presumed innocent. Let me finish, okay? And you'll understand why I'm saying this. You are presumed innocent. So we want to make sure that you don't say anything today that can be used against you. So when you get to talk with your attorney in private, that's when you're going to want to talk about what happened or didn't happen. I can only tell you what the charge is and the penalty is, and then you'll talk to your attorney and they will help you prepare a defense against the charge. Does that make sense?
I'm 29 years old. I understand. Like, you know what I mean? I get it, for real.
3 defendants, 3 very different stories, and 1 chaotic day in court you won't forget. First up, we've got Jacob Mullins, a man accused of setting his own mother's house on fire, all while insisting the legal system is broken. Then we'll meet Rico Gator, a sovereign citizen who believes his corporation is on trial instead of himself. And finally, Robert Corbin, facing animal cruelty and assault charges, but somehow finding the time to argue about switching lawyers. This is a roller coaster of arrogance, delusion, and jaw-dropping courtroom moments. Buckle up, because by the end, you're going to have strong opinions about every one of these defendants, and we want to hear them in the comments.
Good, good. Okay. All right, then, Mr. Mullins, you understand the charge and the maximum penalty. You don't have to agree to it. You just understand. Is that right?
Yeah, no
Okay.
disrespect.
Okay. Perfect. All right, now you do have rights as well. You have the right to plead guilty, not guilty, or stand mute. You have the right to a trial by a judge or a jury, and at that trial you can present or confront witnesses. If they would not appear, the court can order them to do so. You also have the right to a lawyer, and if you cannot afford one, one can be appointed for you at court expense. Additionally, you are presumed innocent, as I said earlier, and if you are found guilty, it has to be beyond a reasonable doubt. You also have the right to remain silent. Anything you say or write can be used against you, and you always have the right to have a lawyer present with you at any time that you are questioned. Do you understand those rights, Mr. Mullins?
You said read anything you say or write can be used against you? Did you say that?
Yes, I did say that. Yes, sir.
Me no speak English on that one, but everything else, yes.
Okay, good. All right, then, is he applying for an attorney today, Mr. Feigelson?
Yes, he is. He presently works with our office on another matter, Your Honor.
Okay, thank you. So, Mr. Mullins, what we're going to do is we have 2 hearings set for you on this. A probable cause conference, which is the first hearing. That is February 6th. That's at 8:30 a.m. with Judge Simmons. excuse me, you are allowed to appear remotely on that. So that's why you will have a colored sheet. I think it's kind of a
Yeah.
bluish green. Yep. Okay, you should have that. So you can appear February 6th at 8:30 a.m. remotely or in person. The second hearing is a preliminary exam. You have to appear in person for that. That's on the 6th floor of City Hall, Courtroom 4, and that's February 13th at 8:30 a.m., also with Judge Simmons. So you've got the notice and the Zoom instructions, correct?
Yes.
Good, good. Okay, now, is there anything I've told you so far that you do not understand?
The one thing I didn't speak English on, yeah, but other than that, yes, everything else.
Notice how the judge tries to slow things down here. She's carefully laying out Mullins' rights, making sure he understands that anything he says can be used against him. This is standard procedure, but Mullins seems eager to jump in with his own version of events. That's risky, because defendants often forget that early in the process, the less you say, the better. Judges don't want your defense right now. They want to confirm you understand the rules. Mullins is about to find out that talking over a judge rarely works out in your favor.
I'm an artist. I've
Okay.
been writing a lot of things, so when I write stuff, it's like almost like, you know what I mean? So that's just a arbitration contract thing that I didn't like. So I mean, we'll settle through that. So I would like to just voice that. Other than
We
that,
could
no
just
disrespect.
move
Yes,
forward, sir. Appreciate the,
correct.
Yeah, you'll talk
Thank you.
about that with your attorney, absolutely. Okay, so Mr. Mullins, I'm going to stop the live stream so that I can protect your.
that he be given a low PR bond or a low cash surety bond, Your Honor. Thank you.
If it's
All
any
right,
money,
thank you.
I can't afford it. Let's just say that. I ain't got nothing to y'all ain't give me any tools to get a job since I've been released from your guys' care. Now, I don't really know what's going on with my
Okay,
support
this
system, but it's
This
burned down
is my
relationship
turn
with
to
my
talk,
family.
Mr. Mullins.
Metaphor.
Okay, you don't want to talk about that because, like I said, you're gonna you might say something that can be used against you. So the court's
Sounds
going to
good.
look at two things, Mr. Mullins. I'm going to look at whether or not you're a flight risk and whether or not you are a danger to the public. In regards to that, I'm going to look at your criminal history. I'm going to look at the allegations. I'm going to look at your ties to the community, your employment status. You live with your parents. I look at all of those to determine two things. I do have a concern for the safety of the public. On the matter that I arraigned you on first, the arson, you are presumed innocent, but as I look at the allegations, it presents a concern to the court for the safety of you and any other individuals that reside in that location. I understand that would be your parents.
1995.
Okay,
Trust me.
this
It's all right.
is my turn, sir. Okay, so
I bought it,
based
too.
on that, I'm not going to grant you a PR bond because I don't find that that is sufficient to ensure your appearance as well as protect the public, as specifically here your parents. The court is going to set a cash surety bond on this of $10,000
What the
to
fuck?
ensure.
Did he just say he didn't speak English on that one part? That's an odd way of admitting you didn't understand something. But here's the problem. The thing he claims not to understand is one of the most important rights he has. If you miss the point that your words and writing can be used against you, you're setting yourself up for trouble. Mullins is showing early signs that he's more interested in challenging the process than actually following it, and that's going to make this bond hearing a lot more complicated.
Okay, now, first of all, the condition of your release is do not miss any court dates and do not violate any state or local laws while you're on bond. You're not to possess, purchase, or consume any alcohol or controlled substances without a prescription, and you're not to leave the state of Michigan without permission from the court. You also are not allowed to possess or purchase any firearms, ammunition, or dangerous weapons, and you will have to report to pretrial services so that they can set up any pretrial supervision that may be necessary. That's either a phone or an in-person interview. Now, I'm also going to tell you, you cannot have any contact with Daniel Mullins and or Barbara Mullins. You cannot call, write, page, email, text, no electronic communications of any kind. You can't have anybody else contact them on your behalf, and no threatening, harassing, or molesting behavior towards them or anyone else. Additionally, you cannot go within 2,000 feet of where where they're located at any time, including work, home, or school. So what that means is if you have property there, someone can go and get your property and get it for you, but you cannot go there and you can't have any contact at all. Also, you're unable to give me an address at this point. So if you are released, you have 24 hours to notify the public defender's office of the address where you're staying. If you don't do that within the 24 hours, the court then sets a bench warrant for you. Do you understand that? Do you understand what I'm telling you, Mr. Mullins?
I understand that our system's broken and I'm just a little cog chilling. Hi, I'm Cog.
This is the first big turning point. No PR bond. Instead, a $10,000 cash bond. Judges set PR bonds when they think a defendant is low risk. The fact that Mullins isn't getting one tells us the court sees him as a danger to the public, specifically to his own parents. That's not a minor detail. It means the court believes the allegations are serious enough that letting him go without collateral could end badly. Mullins can thank both the nature of the charges and his own behavior for that decision.
Okay, all right, let's go over the other file then. This is, again, the 24-03520. Judge Simmons has ordered that you be remanded on that case file because you failed to appear for the probable cause conference. So you will not be released before that hearing that is to be set. Do you understand?
Yeah, y'all tweaking.
All right.
You guys know I have no clue what the hell y'all are doing. You have no details. You're making a bunch of judgments on very, 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 very misguided details. And the frail line understanding that you understand.
You're going to talk with your attorney.
What's the Rotary Club? Who am I? Do you guys know who I am? My name is Jacob Edwin Mullins. You guys know who I am. That's crazy. You guys are playing silly ass games.
Did you have anything else?
I do not, Your Honor. Thank you.
Thank you.
And I am going to order a CMH evaluation on that new file as well.
All right. That's about the one good thing you've done today. And it's not your fault. You're an amazing person, I'm sure. And I'm not trying to hurt your feelings or like I'm a frustrated individual. So let me just say, like, I'm sorry for the disrespect. I know it's not your fault necessarily, but this is just a large structure. So I'll end that.
This is the moment where Mullins completely loses the plot. Instead of addressing the actual bond issue or his upcoming hearings, he spirals into a rant about the Rotary Club and whether the court even knows who he is. This isn't just bad. Courtroom etiquette, it's bad strategy. Judges remember defendants who show disrespect, and even if it doesn't directly affect sentencing, it can influence decisions about bond, scheduling, and how strictly rules are enforced. If Mullins was hoping to convince anyone he's not a threat, this was not the way to do it.
City of Detroit versus Rico Gator. Case number SP-128-1837, counts 1 and 2. SP-156-07261, SP-162-4983, counts 1, 2, and 3. SP-164-3083, counts 1 and counts 2 in the state of Michigan versus Rico Gator, case number SX40380982. Appearance for the record, please, Mr. Barrett.
Elwood S. Berry Jr. on behalf of the defendant. State your full name, Mr. Gator.
I'm speaking for the corporation of Rico Gator.
They're gonna love this one. Good morning to you, Mr. Gator.
Good morning.
All right, today is the date and time, so I kind of got to get an understanding of, we need Mr. Rico Gator. We don't need the corporations of Rico Gator. How do we find Mr. Rico Gator?
I guess that's the name.
Classic sovereign citizen move, pretending not to recognize your own legal name. The idea is to separate the flesh and blood man from the corporate entity the government supposedly created. It's a completely debunked legal theory. But that doesn't stop people like Gator from trying it. The issue: judges have seen this 100 times, and it never ends well. By even entertaining the argument, Gator is burning valuable time that could be used negotiating a deal or as his 9 pending traffic-related charges.
Okay, all right. Today is the day. Now, let me ask you this. Do you want Mr. Berry to represent you, or do you want an attorney to represent you?
Yes.
Okay, good. All right. All right. So today is the date and time set for, it's some matters under warrant status, Mr. Berry, and other matters are in pretrial for the purposes of the warrants. Mr. Berry.
Your Honor, we would waive the reading of the information and stay on mute.
And we'll enter a not guilty plea on your client's behalf and give your client a $0 bond. So what I have here is 1, 2, 3, 4 tickets in Mr. Gator's name. And then I counted some other tickets into the record. I can give you those tickets whenever you're ready.
Ready, Your Honor.
I have a driver's license suspended. I have a no insurance misdemeanor. I have a no ops. I have a failure to stop and an improper turn. So it should be 1, 2, 3, 4, 5, 6, 7, 8, 9 cases I called into the record.
Yes, Your Honor.
2 of them are civil infractions that were in default. I have no problem setting these defaults aside. They were kind of a little bit back in October, but since I just said it, I don't have a problem setting an improper left turn and a failure to signal at a stop sign or whatever that is, if the city has no objection to hearing you.
No objection, Your Honor.
Give Mr. Gator an updated offer. I also see a no insurance, the insurance no proof 288. If Mr. Gator is interested in getting a valid driver's license, he probably want to pay that 288. At least get a port of clearances here at 36 District Court. That's the only thing I can see affecting Mr. Gator's license. Mr. Gator, what I'm going to do is I'm going to put you in a breakout room with Mr. Berry. Have a conversation with him. Let us know what you want to do when you come out, okay? What happened?